Hello and welcome to the new series of Drishti IAS. I am Pooja Divedi, and in this segment today we are going to talk about the Maratha quota debate. This topic is important from the perspective of prelims and also from the perspective of GS Mains Paper 2. So let's begin with the first topic. Why is it in the news? Now the centre has moved to the Supreme Court with a review petition challenging the interpretation of the 102nd Amendment Act. What the centre wants the Supreme Court to interpret it correctly, so that there is no confusion when it comes to identifying and including the names of the socially and educationally backward classes name in the list under Article 342, Clause 1. Now what has happened that the centre has said that the intention of the 102nd Amendment Act is to not take the powers from the states to have the list of socially and educationally backward classes according to their own needs. Many states such as Punjab, Maharashtra, Rajasthan, Karnataka, they have asserted their right that they can maintain a list of the socially and educationally backward classes. And so does if we talk about the centre, so does the centre say that they have the rights, and the insertion of this particular article relating to the reservation does not at all infringe upon the Articles 16 Clause 4 and 15 Clause 4. That is the entire issue. Now, if we talk about the background of it, the ruling of the Supreme Court declared the Maratha quota law unconstitutional few days back. Let's talk about the ruling. The court had framed 6 questions of law on the issue, and it unanimously agreed on 3 of those issues. And the verdict was split in the ratio of 3:2. The first issue was on revisiting the INDRA-SAWHNEY ruling. The ruling by a 9-judge bench in which the Mandal Commission report was upheld, it laid down 2 important precedents. First was, it said that the criteria for a group to qualify for reservation is social and educational backwardness. We should identify a group for reservation only when they are socially and educationally backward. This was the ruling in INDRA-SAWHNEY case. And it reiterated that there should be a cap limit of 50%, upper cap, on the vertical quotas are different from horizontal quota. And the reasoning that it was needed to ensure efficiency and in administration, in the sense that there could be reservation for socially and educationally backward classes, but merit should not be compromised. However, the court said that this 50% limit will apply unless in exceptional circumstances. So here, what the Maharashtra government said, it said that the 50% limit of INDRA-SAWHNEY case, which was not given in the constitution, this has to be referred to a 11-judge bench. But the Supreme Court said that although it's not written in the constitution, this is still constitutionally accepted that the cap should be of 50%. Secondly, after they have made their decision on the cap, that this cap is constitutionally accepted nowadays, the second one was on whether Maratha law can be saved under the exception. Here, as you can see, that the cap can be breached only in exceptional circumstances. So, since this 50% ceiling is held valid, the court looked into whether the Maratha quota law falls under the exceptional circumstances contemplated by the Constitution bench in the INDRA-SAWHNEY case. The court also looked into the Maharashtra State Backward Commission report that the Maharashtra government had relied on to see if a case can be made out for exceptional circumstances. The state government's argument was that since the population of backward class is 85% and reservation limit is only 50%, an increase in reservation limit would qualify as an extraordinary circumstance because population is huge. When it comes to Marathi speaking population in Maharashtra is huge and the reservation is not proportional enough. This is what the state government wants to say. Now, if we talk about Marathas, who are they? They are actually a warrior clan, and very hugely, they have a huge influence in the political structure of Maharashtra. About 1/3 of the population is Maratha. And out of 18 chief ministers of Maharashtra, 11 were from, if we talk about their clan, they were Marathas and they belong to the landholder group. Agrarian crisis has caused a lot of, it has actually ripped off the prosperity of this particular group, and that is why they want reservation. And the next issue that came to the state's highlight was that on states' power to identify socially economically backward class and 102nd Amendment Act. Now, the Constitution 102nd Amendment Act 2018, it gives constitutional status to National Backward Classes Commission, and the amendment also gives the President powers to notify backward classes. Several states have raised question to the interpretation of the amendment and argued that it curtails their power. And the bench unanimously upheld here that the constitutional validity of the 102nd Amendment, but differed on the question whether it affected the powers of the states to identify socially and educationally backward class. And Attorney General K.K. Venugopal, appearing for the central government, clarified that this was not the intention of the law. Now, what is the problem here? The problem is that the court has interpreted that the President holds the entire and the final conclusive power to identify and include certain groups as socially and economically backward classes. That means the parliament will be in the picture. But many states want to have their own list. And this is what the central government is also saying, that we do not have this intention that the President will have the power in his hand, conclusive power in his hand, to have a list that will be mandated or imposed upon every state. This is the problem over here that we are talking today. Moving on, let's talk about the background. Maratha, as I already told you, they are a very influential group in Maharashtra, and the demand for Maratha as a reservation was first mooted in 1980s, and in 1992, the Maratha Mahasangh had made a representation to the state government to provide reservation to the community. The NCP was the first party that had promised to provide reservation to the community in its 2009 election manifesto. In July 2014, the Congress NCP government had brought in an ordinance for 16% Maratha quota, but it failed the legal test. The subsequent BJP government in 2014 came out with an act to provide reservation for the community, but the proposal also did not stand the scrutiny of the court. And there were large-scale protests. In November 2018, the state legislature again passed an act proposing 16% reservation in education and government jobs for the community and declared as socially and educationally backward classes by the government. Moving on, the Maharashtra State Reservation for Socially and Educationally Backward Classes Act 2018 was then challenged in Bombay High Court, terming it as violative of Supreme Court order that reservations in any state cannot exceed 50%. Let's talk about INDRA-SAWHNEY case. In 1979, the second Backward Class Commission, Mandal Commission, was set up. It was tasked to determine the criteria for defining the socially and educationally backward classes. The Mandal report identified 52% of the population at that time as socially and educationally backward classes and recommended 27% as reservation for them. This was in addition to the previously existing 22.5% reservation for SCs and STs, and in 1990, the VP Singh-led government set out to implement the Mandal Commission recommendation. This was challenged in court amidst widespread protests against the move, and the case came up before a 9-judge bench. A 6-3 verdict was delivered in 1992, popularly known as the INDRA-SAWHNEY judgment, and the court upheld the office memorandums that essentially implemented the Mandal report. What was the verdict? The executive orders mandating 27% reservation for backward castes were said to be valid. The reservation was made not just on the basis of caste, even if it appeared so. It is also mandated, or it is also made on the basis of objective evaluation of social and educationally backwardness of classes, which is the criterion previously laid down by the court. The landmark INDRA-SAWHNEY case, it set out two important precedents. We have already discussed this one and also this one. Alright, it reasoned that this was needed to ensure efficiency. Of course, reservation was upheld, but efficiency should not be compromised. Now, the court said that 50% of the limit will apply unless in exceptional circumstances. The social and educational backwardness criteria stemmed from interpretation of the various constitutional provisions, but the 50% limit is often criticized as being an arbitrary limit. Let's talk about 102nd Constitution Amendment Act. 102nd Constitution Amendment Act 2018 provides constitutional status to NCBC. It has the authority to examine complaints and welfare measures regarding socially and educationally backward classes. Previously, NCBC was a statutory body under the Ministry of Social Justice and Empowerment. Article 340 deals with the need to inter alia identify those socially and educationally backward classes, understand the conditions of their backwardness, and make recommendations to remove the difficulties faced. 102nd Constitution Amendment Act inserted two new articles, Article 338B and 342A. The amendment also brings about changes in Article 366, and Article 338B provides authority to NCBC to examine complaints and welfare measures regarding socially and educationally backward classes. Article 342A empowers the President to specify socially and educationally backward classes in various states and union territories. This is the entire problem if we talk about the current issue. He can do this in consultation with the governor here of concerned state. However, law enacted by the Parliament will be required if list of backward classes is to be amended. Here, as you can see, President can take the consultation of the governor. Now, the state comes into the picture. So, they have a say in that they need this particular group to be stated as social and educationally backward class. But Parliament will be required. Parliament cannot be put out of the picture. That is the text, what it is suggesting. Moving forward, let's talk about the impacts. The biggest impact is that numerous states have their own groups which they consider as socially and educationally backward. If they do not have the right to provide them with the necessary improvements, provide them with the necessary protection, what is the point of federalism? How does this impact interventions by other states to provide reservation for other communities, for example, Jats in Haryana and Kapus in Andhra? The majority opinion by Justice Bhatt in this case essentially says that now the National Backward Classes Commission must publish a fresh list of socially and educationally backward classes both for states and the central list, which is a long drawn process, right? Moving on, let's talk about the conclusion. First, due process of law should be followed. Tell me in the comment segment what is due process of law. If constitutional procedures are followed properly, then it might take a lot of time, but it will definitely save the entire country the agitation, the protest, the ruckus it creates. That is the first thing that we should move forward. Second, merit shouldn't be compromised. Reservation should be provided, and it should be provided judiciously, should be provided proportionally, and merit should always take the first and foremost lead, because merit, if it is compromised, then proper quality, the quality will also be compromised, of course. So that is the second thing. Curbing political ambitions, in the sense that many a times what happens, in order to gain very short-term political victories, the groups are politicized in such a manner that they are given a particular way to look at, they are given a particular destination to strive for, and it might in the end not be very good for the entire country. So political ambitions should be curbed. Let's move on to our mains question. Reservation is not a fundamental right. Discuss in the light of recent verdict of the Supreme Court. Alright, so that's it for today. Tomorrow we shall meet again with another segment. Until then, stay updated, stay very safe, and thank you so much for watching.